Good day, everyone. I'm Richard Fink. Today is another session of the Workers' Legal Side podcast with Richard and Paul.
Hello, everyone. My name is Paul Taylor. I'm a licensed paralegal by the Law Society of Ontario with specialization in workers' compensation and human rights law. If you want to reach out to either one of us or be part of our podcast, like Pam here today, you can contact us through the links below. This week's topic is challenges with administrative challenges with the WSIB. Ooh, my favorite subject, Pam.
Yes, let me just introduce Pam for a second. Pam is the legal assistant with Fink and Bornstein, my law firm. Uh, she's been with us for some 30 years. She's been fighting with the WSIB for equal length of time. And today she's going to give us an update in trying to deal with the WSIB on their administrative issues. Thanks.
So just to correct, I've been with you for 20 years. It feels like 30 years because of how much time has passed and what's changed over the years. But yes, thank you. So yeah, I've been working with Richard since 2005. Richard taught me everything that I know with WSIB. I never learned it in school. I simply went to Humber College to become a law clerk and then was taught by Richard over the last 20 years. So today is to discuss challenges with dealing with the WSIB, both for injured workers' knowledge as well as representatives. I guess what I'll do is I'll go through from start some challenges that we see and some tips for people. So the first challenge that I always see is as soon as we are represented by an injured worker and we have to submit a letter, the letter gets sent through the WSIB's document upload tool. So for anybody that is not aware of this, you go onto the WSIB's website. You can say if you're a rep or an injured worker, whatnot, put in the name, claim number, date of birth, and then you can upload documents. Then it takes you to a page that says, what are you uploading or what do you want? So this is where I have complained for numerous years with the WSIB because when we're sending in an initial letter, we are saying we are the representative of the worker and we are saying we want a copy of the file. The WSIB's upload tool cannot take more than one answer. So you either have to say you're submitting an authorization form or you're requesting file access. Our go-to is to say other because we've complained about this and the WSIB's answer to us is we can't fix this problem, so you should just send two letters asking for two different things. So in other words, you're providing more work on the injured worker or the representative to then have to upload this information. So our go-to is to say other. That unfortunately is not good enough. So once this is done, 2 to 3 business days later, I am calling the WSIB to say, I sent this letter. Can you please tell me who the case manager is? And I want their contact information so I can call them to tell them what we're requesting. Because unfortunately, as silly as it sounds, it's not good enough to just upload something to the WSIB. You then have to notify them to make sure that it's being documented properly. So one of the first challenges you will always see with the WSIB is documents not being filed properly, notifications not going to case managers, or my favorite one is there is no case manager assigned, so it will sit there in limbo until you actually call the WSIB to follow up. So with that being the first challenge, Paul, do you see things like this happening when you're dealing with injured workers?
Are you in my system, by the way? Because it seems like you are. Now, I will concede for the first time in my life, I did what the WSIB said. I'll send a stupid. Okay, so I deal and I practice, as I said, human rights and workers' compensation law, but I also practice in criminal law, small claims court, which is civil law, up to now $50,000, and landlord tenant and things like this. So the rule is, and according to Law Society, is it is proper to notify the forum, the court, the board, or whoever, that you have been retained on this matter by who, and then also to notify the other side if there is another side, like the employer or the Crown prosecutor in the case of criminal, or in civil, the defense counsel, or whatever. So I have a standard letter I do, and that's the one I do. Then, unfortunately, because the WSIB has their own system and we cannot change it, then I attach, or I do, then now I go through the whole stupid process again to attach that I would attach the authorization form to the letter, and then to request claim file access. And this is another thing that you might have, well, maybe not missed. I don't like now. Okay. Years ago, when you get claim file access, it used to be in paper. I'm sure Richard remembers. Sorry. And it used to be cases. My file was literally a case, and you go through it. The procedure for the WSIB then, which made sense, was they would then they would send you on first time, they would send you a copy of your claim file. And surprisingly, Pamela, I deal with Manitoba and Alberta as well. And I hate to say this, but I will give credit where credit's due. WSIB does do a relatively good job in organizing the file.
Mhm.
Manitoba, you just get the documents. There is no separation, there is no organization. That's it. So the WSIB will organize the file and they will send it to you. That's your first copy. Any subsequent copies requested are automatically what they call as updates. I don't want an update. I want a complete entire copy of the file, and I want an electronic copy. So what I do is I literally modify their form and say that on the form. Want a complete copy of the file because I want it from start to finish. Because if Richard's my client and he's the injured worker, yeah, sure, they'll say, well, get it from him. And Richard knows from experience, which is just a little bit, right, Richard? That sometimes things get misplaced, stolen, whatever happens. Stolen, what am I talking about? Misplaced, right? And in that situation, I'm not dealing with the full picture. It's best to get it from the board, especially today when it is digital and it's nothing for them to do it. I don't understand why they do that, but that's the way. So I make that very clear with them. I want an entire copy of the file. Now, get this, Pamela. Here's an interesting point of information. In Manitoba, the board gives the worker one file, copy of it. They will give them any updates for free. If they need any additional copies, the injured worker has to pay. So I'm like, whoa, that's
That's
not good.
crazy. Yeah.
Now, I know Manitoba's NDP and they're actually getting ready to review their system. And that was one of the points that I raised with them, is saying this has got to stop because I've yet to meet a wealthy injured worker. Like that's just, and I also said it's a point about procedural fairness. How can they fairly make their case when they don't? So yeah, I do agree with you. It's a point of expediency with the representative side, not just lawyers and paralegals, but even the Office of the Worker Advisor and legal aid, who are government funded and funded by the WSIB, the OWA, that it would be a cost saving measure to just do it the way you said. That makes so much more sense. And
Hmm.
their computers and the algorithms, they can separate and do their thing if they have to.
How long does it take for us to get the file?
Oh, that's
So
another good one.
yeah, so that was part of this. So when you actually speak with a case manager and they say, I'm going to do the referral to the access department today, you're looking at minimum of 4 to 6 weeks. Because what people don't realize is the case manager has to go through the file, redact any necessary information, send it to the access department, then the access department has to process it, and then they are the ones that are then emailing it to us. So when you send something in and the board website says, okay, yeah, you're going to get it within 30 days, what they don't tell you is the fine print, which is it's 30 days from the date that the case manager actually sends it over as a referral to the access department, which again, 90% of the time does not happen without you doing a phone call, or it gets delayed by several months until a case manager looks at the file.
So it's 4 to 6 weeks from when you put in the initial correspondence or longer?
4 to 6 weeks from when the case manager actually actions the correspondence.
So it may be a week or two before they actually get the correspondence to action.
It could take longer than that because that was my next topic of challenge, which is the WSIB is supposed to look at each injured worker's file every 30 days. They then said it goes every 30 to 45 days. What ends up happening is When documents come in, it might not be the case manager's time to review the file. So what ends up happening is it will sit there if you don't call to notify them that there's something that you want them to action. They won't look at it. Then let's say the 30-day mark comes and they're absent, they're on vacation, they're busy. They can actually they can extend it and just keep pushing it. So that's a common issue that happens not just with access, but with any request that you can send in. They're not going to look at it unless you call them and politely say to them, listen, I sent something in. Can you make sure you take a look at it? Can you let me know when this file is up for review? And can you call me and let me know when you can complete what I'm asking of you? Which is a huge problem because, again, the WSIB holds everybody to time limits, but then themselves very rarely meet these time limitations.
Isn't that the irony of life? Here's an example. I have a client and I sent a request for the complete copy of the claim file September 10th. No response. So then October 10th, according to my notes, I forwarded the original request and said follow-up request for claim file. And that's been now 10 days from the second request and no response. Now, I don't know. I was just looking at the system and it was just a suggestion because quite honestly, it's not that I don't like talking to the W to people, I do. And the lawyer in my brain, I know I'm not a lawyer, but that lawyer thinking kicks in and I like to document everything.
Yep.
So, I mean, I don't like calling them for the simple reason of even if I document it, it becomes question. Whereas if I send them a message or an email, which Ontario doesn't email, by the way, Alberta, Saskatchewan, Manitoba, and BC all can email the case managers, so on and so forth. Why WSIB won't do email, I don't know. I like it because that's one of the reasons is I can send a follow-up email to the case manager, not to harass them or anything, but it would be like a reminder. Like I tell my clients that, hey, if you don't hear from me, yeah, call me. Hey, what's going on? It's a great reminder. And it's quick and it's easier. But yeah, I don't get why they don't. I mean, I understand security and everything, but I don't
That's
know.
that's not really, I think what happens is because the WSIB staff deals with so many files, they just don't have the means to be looking into the file and then they run another computer program to internally communicate. So you can't email a case manager, but we have emails for directors and above. We also have emails for people like the WSIB auditor you can email if you have an employer matter. So there are people that you can email. I think the main issue with case managers is years and years ago, I'm sure you guys remember, when a case manager got changed, you would get a letter saying your case manager has changed. Here's your new case manager, right?
You
They don't do that anymore. So now we get calls all the time and our clients are in panic going, "Oh, I just found out I was calling about reimbursement for something and I have a new case manager. They didn't tell me. What am I supposed to do?" And I keep saying to them, that's the thing, is that you will have so many case managers assigned to your file over years. And if the case manager puts in wrong information, case manager number one, case manager number five is not going back to the start of your claim. They're picking up where each of these case managers have left off. And unless you actually write to them and say, I found this in the file and it's wrong, it stays incorrect throughout your file. And that's the same with decisions, right? I mean, this is just what happens. I just think you can't email a case manager because it's too difficult on the WSIB for how they're going to handle that, right? Because one case manager is not there. Also, things like people leave the board all the time, or they go on absentee alert for long periods of time, or they're on vacation, then all of their emails will get backed up. So that's why we always, like, I'll call a case manager that I see was last assigned to the file. But if I don't get a call back, I'll call back the general line and say, is this still the case manager? If not, I find out who it is. If it is still the case manager and I haven't gotten a call back and it's been a week, I'm calling their manager to complain because that's what people don't probably think about is everybody has a manager. So there's a case manager. If they don't answer you, you go to the manager. If the manager doesn't answer you, you go to the assistant director. And the customer service representatives are going to give you this information if you ask for it. You can also complain to Fair Practices Commission. Now, Fair Practices Commission, all they do is they can internally look at what's been done on the file, why hasn't your stuff been answered, and they can give a little nudge. Other than that, they can't help you like to overturn decisions, but they're there as a good tool to try and help you to communicate with the WSIB when you've taken these measures and you don't get the answers.
The last podcast we had was with Karen Lundy talking about time limits. Does our initial letter asking for file access have any effect in preserving time limits?
So what we used to do is we used to have our blanket initial letter that used to say along the lines of, we represent this worker. Here's our authorization form. We wish to appeal any negative decisions under the claim. Give us full file access, either pursuant to our appeal or under freedom of information. We got a call a couple years ago that says you're no longer allowed to do that. You're not allowed to do a blanket appeal without specifically outlining a decision letter. So we found a gray area. And so now what we do is we say, please provide us with a list of all of the decisions that have been rendered under the claim. And if they don't provide it to us and we miss the deadline, then that's what we submit to say, look, we sent this to you, you guys didn't answer, and then that allows us to extend the time. So they've changed it over the years. I mean, if we look at just 2024 and 2025, they tried to remove the ability for law clerks, admin staff at law firms, paralegals to be able to communicate with the WSIB without doing the amended authorization form. So we had to send out the authorization form to every single one of our clients to put my name on it, and they had to sign it, and we had to resend it in. And if our client never sent that back and my name is not on there, they won't talk to me. They will only give me what they refer to as general information, which is the case manager's name and their phone number. That's pretty much all they want to give to me. And then I can leave a message for the case manager and they'll get back to me because most of them know me after 20 years. But they were making it, and continue for some other places, make it extremely difficult for anybody that's not a paralegal or lawyer that's on the file to actually call the board to get information, which is crazy to me.
Pam, have you ever, I hope you've never been an injured worker.
No, I have not.
Sorry, I'm just trying to log in
Are
now.
you trying to tell her to take stress leave?
No, what I was trying to say is that the WSIB a few years ago came up with their portal system for injured workers. I know they have a system for the employer, and to my understanding, it's quite robust. The employer has quite a bit of access to information. Same thing with the doctors; they have access. I don't know what degree, but the one I do know about is it looks like for reps with the WSIB represented lawyers, paralegal, whatever. They can only submit documents, that's it. But as the injured worker, I can actually view my claim file.
Yep.
But there's nothing really there. And that's why I keep saying to them when they say, what do you think? And I go, well, it sucks. There's nothing there. And there isn't, partly because my claim file is really old and the information hasn't been updated onto their, so to speak, modern system. That said, I don't care. It should be the same across the board, right?
Hmm.
And I think that one thing that I would like to see, which I think would be more efficient, is that if the representative could gain access to the claim file like what we get as the PDF and electronic version. So, in other words, once you've been authorized by the injured worker to represent them, you can then gain access to like a representative portal where you can see everything. You can directly message the case managers because there's probably going to be different ones, and then you can see the claim file and you can see exactly what's going on. Like you can see what the case manager sees. Because the one issue I have from day one as an injured worker with paper files is, for example, when somebody was saying something about me and they put it on my file, I didn't know about it until years later when I got a claim access. It's not like the board will freely go, oh, by the way, this person said this about you. And it's very hard to then defend it years later.
Yeah,
What
I
do you think
mean,
of that, Pamela?
okay, so earlier this year, I got invited to do, as the first person ever, to test out the WSIB's pilot project to doing a representative portal. So essentially, they contacted a bunch of people. They said, do you want to go through this? We'll sit with you. It's a couple hours. We're going to have you go through each page and see what happens. to be quite honest, I have no idea why that much money would be spent and wasted on doing that without speaking with injured worker reps first. Because essentially what it was I will log into this portal, I cannot get a copy of the file. What I can do is I can view letters, but I can't save them or print them. They are view only. I then have to wait for them to come by fax or mail anyways. But essentially, it's like, oh, a week in advance, I can see a letter that I'm going to get anyways. You can't internally communicate with the WSIB, and no, absolutely not, cannot get a copy of the claim file.
Yeah,
So
like
it just doesn't make sense to me. Like, if you're going to create something and it's supposed to be easy
have a
using
purpose.
for the reps, why wouldn't you reach out to representatives and law clerks, like people that are doing this daily, and say, what do you think would make your life easier? And the weirdest part about all of this is every time I go to the WSIB to complain about something they do, I always say, look, it's not just for us. This is making your lives easier. Like if you guys could provide us with file access, you're then like electronically, you're then relieving all of these people who have to go and do it manually. Why wouldn't you do that to make it easier on both sides? Right? I mean, at the end of the day, it's very, very frustrating because we all know about the $6 billion that was given back to employers. $8 billion given back to employers under Ford, pressing through everything. Like we know about all of this. The frustration lies is that every time I talk to the WSIB about why wasn't this done within the recommended time frame or the time frame that's on your website, I get we're short staffed and we're backlogged, which poses the question of if you have all of this money, why is the Ford government pushing to give it back to employers? Like, first of all, you're
Yeah.
taking it out of injured workers. It's meant there for injured workers. And then you're going to give it back to employers. We have no idea what happened with it. That's a totally different story. They say that the money went somewhere, who knows? But at the end of the day, that money should be going to have more staff at the WSIB, better medical treatment, faster medical treatment. Like these are all the challenges that all of these people are seeing. But like we've heard from our other people on the podcast, like even Dr. Corey said, is that the WSIB's goal is not to get people recovered and better. It's to get them back to work so that their benefits can be cut off or cut down. And that's what the major challenge is. So, I mean, the whole purpose of today was to just kind of say, look, reps, staff of reps, and injured workers all face the same problem. We're all having an issue where you have to advocate for yourself, you have to advocate for your clients, you have to call the WSIB more than you probably feel comfortable doing to make sure that they're not dropping the ball and they're doing stuff, or else things will just sit there and they never get done. And there's always going to be an excuse on their side as to why things aren't being done.
Let me just say about file access, which is where we started. We can obtain from the injured worker some basic information as to their history. But in terms of seeing all the medical reports, their conversations with board staff, what types of decisions they've had, to see all that, which is you need in order to help an injured worker, we need file access. And the file access comes anywhere from a few hundred pages to a few thousand pages.
Yeah.
So we're talking a lot. So we're kind of done helping the injured worker without the file access first. The question I have for Pam is we've got AI running around now. So AI presumably could read the file and answer questions. There are law firms using AI where AI documents and sends summaries to the lawyers as to what's gone on in the file for the previous year. Do you hear anything about AI from the WSIB?
So the WSIB during their work disruption was rolling out some form of AI algorithm to help decide on entitlement of claims, which is mind blowing to me because you can't just say this person was injured, this is what happened, and a computer is going to spit out whether or not they're entitled to something or not. I mean, at the end of the day, I again just think that this is let's spend money on something that is not going to work. And it's just going to deny claims the same way as human case managers do, unfortunately. Like, I just don't think that AI is a good fit for WSIB in general, whether it be a law firm reviewing a file. I just don't think it's advanced enough. I think that WSIB law is very, very difficult. I think everything should go case by case. That's not clearly what happens with the WSIB, but I just don't think that it is very useful. Um, but the WSIB all the time, like we get emails saying, oh, they're going to try this AI thing to see if it works, and then it just kind of goes away. You don't get an update about it. So, I mean, the last time I heard about it was during the work disruption that they were trying to roll it out. That was when they were saying, oh, everything is normal, even though there's a work disruption. And then we find out after that various different departments at the WSIB were put down to case manager levels even after the work disruption because of how backlogged they were. So, again, to me, it doesn't make logical sense. I don't know if I'm missing something, but if you're going to have the money to spend for AI and doing things like that, I think it would be better spent to actually help injured workers, give them medical treatment, get more staff, train the staff better at the WSIB, and just try to actually help people rather than just try to push them out the door.
What's your experience with the return to work specialist at the WSIB? Are they trying to help get the worker reemployed in some form?
I think years ago, it was more likely that return to work specialists were there to help. Over the years, more recently, let's say in the last 5 years, I think that the return to work specialists are only there to obtain information, relay it to a manager and a case manager who are then going to make a decision. And I can give a quick example. I participated in a return to work meeting where I was solely there just to take notes virtually. And at the beginning of the meeting, the return to work specialist outright said to the employer, you actually don't even need to have this meeting. Whether you take the injured worker back or not, we will not fine you. You're outside of your reemployment obligation. So I'm not really sure why we're here. And decided in the middle of the meeting, while we were talking about getting this worker back to work, because the accident employer was willing to try and do a graduated return to work, the return to work specialist got up and said, I have a personal phone call, and walked out of the room. I complained about this in a 3-page complaint letter with all of my details to the president of the WSIB. And as per usual, I get back a letter that says, this is not all of the WSIB staff. This was a one off, and some political response that they will try and do better. So, again, I think that what it comes down to is what can we do to cut people's benefits off? It's not about getting people to return to work where something's actually suitable. It's where do we have to go? What do we have to do? What steps have to be taken so that the button can be pushed and either you're determined to go back to work and your benefits are cut off, or the person gets forced back, they don't want to go, and then they just cut off their benefits for non-cooperation.
Yeah, sorry, Pamela. I just wanted to talk quickly about the portal for me as an injured worker. And you said you got nothing, and they've changed it a lot. And I will admit, I don't regularly check my own personal portal because I'm busy. But did you know I can actually object to an appeal? I can appeal, object to a decision, track my appeal, and see the status of it within the WSIB appeals um, on the portal system for injured workers. It just, I don't get why this information wouldn't be, or why they wouldn't have a system for reps. I understand the board, and this is what the board always defaults to, is privacy and security, and I get that. But at the same time, you're dealing, Ontario is unique from any other province in Canada where pretty much all reps have to be licensed by Law Society, the exception union and such. But even there, it's a tighter group, is what I'm trying to say, compared to Manitoba or Alberta. I know Manitoba and Alberta also have a portal system for the injured workers, but I don't know off the top of my head if they have anything for reps that would, you know what I mean, make the system more efficient and streamlined for both the rep and the appeals department and that stuff. I'm not talking about the appeals tribunal or commission in the other provinces around Ontario. I'm specifically talking about, like in Ontario, the WSIB appeals division, or in Alberta, the DDRD or whatever it's called, their internal appeal. Same with Manitoba and that. Um, I really I'm struggling to comprehend all this money that they put into their system for the injured worker to access limited information, and yet it's of no use or good. Like I say, I've been waiting now 2.5 months for a claim file access from my client that had I gotten it right away, we could have reacted and I could have better served them better along with the board. And not to get off topic, it was funny because the board listed all my prescription medications that they approved and disapproved. And it's funny how they do it. They do give information now, which is like, oh, that's interesting. But then they just say allowed and not allowed, and they don't say any reason, no decision,
Yeah.
nothing. So, I mean, like, they've got, I mean, they're getting better from when I was first injured in 97 to today, like looking at that claim file of mine from 97. But they've still got a long way to go to give transparency to injured workers and to reps in order to make the system more efficient and fair. Um, I do hang my hat heavily on that point of I don't ever want to hear the WSIB say we only have limited resources or we don't have the money, we can't do that because that's just BS right now. The other point I wanted to mention and bring up with you, Pam, was in one injured worker case, I had their claim file, I was ready to do the appeal, and the intent to object had already been sent in, but they never sent me their claim file and the appeals readiness form. So I said, well, to hell with it. I have a blank one, I'll just fill it out, and I did.
Yep.
And they actually rejected it. And I'm like, wait, what? And they said, no, you have to use our form. I'm like, that is your form. No,
You
you have
have
to
to
use
wait.
this one.
Yep. They changed that over the years.
And I'm like,
Yeah.
what? Like, I mean, I get that they have administrative rules and processes, and that's cool. But when they become so, I guess the only word to describe it, correct me if I'm wrong, is anal retentive, that it actually raises concern about my client being denied the justice, that becomes a procedural fairness question, in my opinion. And I really want to raise this point that I heard yesterday, and I literally almost fell off the couch. I keep saying that, but it's not true. I don't If I fell, I'd be in trouble. But seriously, I was in shock when, we're hearing about these delays across the system. HRTO is 5 to 10 years.
Yeah.
LAT was, I think he said 6 months, and I've heard as long as 5 years. And now I just heard in the news that they said that people applying for citizenship, I don't know the specifics, in Canada will have to wait 50 years to find out if they can be a Canadian citizen. I'm like, when is the courts going to wake up and go, okay, that's enough? You know what I mean?
Yeah,
And it's
I
the
know.
same thing with the board and the tribunal workers' comp is when they're going so out of wild crazy. It's not that like my view is the courts are the checks and balances in our society, and they need to say, okay, you're crossing the line, get back over. And it seems like, in my opinion, they're just very like hands off. They don't want to do anything.
No,
I
and
mean, totally wrong. I'm sure Dr. Daly, Paul Daly, would go, well, no, I don't know.
I want to go back to one thing very quickly that you mentioned. So the appeal readiness form before, if you had one in the file, you were allowed to send it in. I found out from an internal staff member at the WSIB that the reason why they changed that was because of how big of a backlog there is at the Appeal Services Division. So the Appeal Services Division is so backlogged right now that case managers have to basically it gives you the extra time. So it's trying to stop the backlog. So if you can't send in a form that you already have and you have to wait, let's say 4 to 6 weeks to get your updated file access with the appeal readiness form, then that's delaying your appeal to go to the appeal services by that much time. So the appeal services division right now is approximately 6 months backlogged unless you call them and you ask them to expedite your appeal because it has to do with return to work and or LOE benefits and you're not getting LOE benefits right now. Then you can ask them to expedite it. Otherwise, it takes its regular course and you're looking right now at approximately 6 months from the date that you send in the appeal readiness form until it gets to the appeal services division and it's assigned. Then they have to determine whether or not to do a written or an oral hearing. So was told by staff at the WSIB that this was all done to delay the amount of appeals going to the appeal services division. Because remember, the percentage of appeals that get overturned at the ARO level, appeal services division, and at WSIAT is like 40% and 50% for the people who actually proceed with appeals. So, I mean, it's just crazy. Like at the WSIB level, the percentage of people getting denied is probably like 95%, unless it's like you have a strain and you're going back to work or you broke your finger and it's very limited entitlement. But for people that have
Long
permanent
term.
impairments, long-term chronic pain disability, psychological impairments that people can't see, so they, want to deny it. Those are all of the issues that are, those are the challenges that people are mostly facing is people that are in that category, not people that are going back to work in a month or two.
A
How do
quick
our
thing.
clients react to all this that you're saying, which essentially is delay and ignore?
I have to sit on the phone with 75% of our clients weekly because what happens is they'll call our office and they want to speak with somebody about what's going on and what's the delay. Once I can actually sit on the phone with somebody and say, look, this is what the process is, this is what I've been doing, this is what the other staff's been doing in terms of calling, they're not as frustrated with us. They're still frustrated about the situation. But I think at the end of the day, what everybody keeps complaining about is the WSIB has all this money, enough money to go and give back to employers. Why is this happening to me? Because at the end of the day, the one thing like that I don't think that the public and people that don't have to deal with this because they've been injured or know somebody that's been injured is the WSIB wants to cut off benefits. This is how they make money. If you deny 100 people's claims, 50% of those people are going to go away because they don't have the financial means and or the educational smarts to know what to do. So what happens to these people? They go to CPP disability, they go to ODSP, they go to EI, they go to Ontario Works. And then what happens is the WSIB saves their money because they don't have to deal with any appeals or paying out benefits. And then all of the taxpayers' money is being drained because all of these injured workers that should be getting WSIB are going to other government funding. And then our taxes go up. I don't understand why people aren't contacting MPPs, complaining about Ford giving back this money, why people aren't making more noise about this to say, hey, like something has to be done with this. What is happening? Like, look at it under a microscope. What are you doing with this money? Where is it going? It's crazy to me. And I think what happens is we're just in this decade, I guess you'll say, where people don't care unless it's affecting them directly. So, I mean, as long as I can go and talk to our clients and explain what's going on, they feel more comfortable. But at the end of the day, none of this should be happening. They should be getting their claims dealt with timely, and there shouldn't be so many denials.
Yeah.
Well, thanks very much, Pam,
You're welcome.
for that pessimistic insight.
The other,
Anytime. We could have gone on for hours about this.
I know, I just wanted to bring up this decision again that I mentioned is that the one problem that I have with the board sometimes is, and you were talking about administrative, but when I'm requesting decisions on issues and I've found two category or two items that the board seemingly, and I could be wrong, is literally just not making a decision on. One is employability. This is something that the WSIB has said covertly that we are just not going to do. And it's illegal, by the way. In private insurance, if they were a private insurance company, they would be in a lot of trouble by the courts. They identified it, and I compared it to disability insurance, right? So it is a wrong, as it were. But seemingly the board gets away with doing it. The other is the age 65 issue where Richard's been working hard with John McKinnon on building a case. And I said, yeah, okay, I've got a couple clients, I'll do that. And I did that. And I mentioned to you, I sent them the letter and a follow up, and I got the letter from the case manager perfectly written. Well, it was what I wanted, which was no basic. I mean, they went into detail, and it
Yeah.
was good, and it was what you would expect from a good decision maker. Then when I filed it to appeal to the WSIB appeals, they were like they threw up their gatekeeper and said, "No, we're not doing anything with this." And I'm like, "No, you can't do that." And my point was, and I bounced it off Richard and you and John, and there was different variations. And the other option is if you get into a situation like that, you can try and just skip over that. Like, so right now I'm at the WSIB appeals and they're like, we're not going to decide. No, we don't want to. So you can skip over them and go to the next step if there is a next step. In this case, it's the WSIAT and say, basically, look, they're refusing to make a decision on this issue. And the WSIAT, and I have one of my own cases where the intake person's like, no, we can't deal with it. We need a decision. I said, no, actually, you can. Because making a decision or refusing to make a decision is, in effect, making a decision in the negative. That's how it
Yep.
should be treated. And the decision was 943/17 is the one you would quote. And it was the WSIAT that said that because the WSIB appeals refused to make a decision on an issue. And I think that may help some reps in that because you get a lot of back and forth
Yep.
where you'll go to the tribunal, get a decision, you're like, awesome. And then it's the other issue is that back and forthness. And if the decision is very clear to pay benefits from this period to this period, and if the board's like, no, I'm not going to, in that situation, and that's where I get all excited, is because in that case, the tribunal decision, in my opinion, is the very same as a court decision. And then when somebody is not complying with a court decision and you want to enforce it, then you literally go to a court and you ask for a contempt charge to be held against whoever. And
Hmm.
that would be, in this case, the WSIB. There was actually a case in Alberta where an injured worker, he was denied benefits for whatever. He went to the appeals commission and he won the appeal. And the decision went to them, and he went, "Okay, give me my benefits." They go, "No, no, we don't. No, we're not going to." It's like, okay, so what do you do then? He hired a lawyer like Richard. The lawyer went to court, and they filed what's called as an application for judicial review, but it was called a writ of mandamus, which is Latin for "we command thee." And he basically, in the writ, he was asking the judge to order the board to comply with the tribunal's order. And in that, I love what the judge finished off with saying. And he said, because it really brought the truth about rule of law. And he said, you may not think you have to follow the appeals commission, but you will follow my order because if you don't, I will hold you in contempt. And they did. Once you realize that you're kind of out of your lane and you've really pushed too far, when you get that realization, usually it's when a judge is telling you, then you're like, oops. And I think sadly, I think sometimes that's what's needed with organizations like the WSIB where they do cross the lines. I mean, you bend over backwards trying to not have to go that route.
All right,
Now
Paul.
you might have to. Okay, I'm done.
Thanks everyone for today,
Thanks, everyone.
and we'll catch you again next week.
Yeah.
Thank you. Take care, everybody. Bye.